If a trust is newly created and the deed name changes to match the trust name, will property taxes increase? It depends. So there's many different types of trusts that can be created for many different types of purposes. With some trusts, the trustee is the same person that is actually putting the property into the trust. That's usually called the grantor or the settlor. And when we have that type of a scenario, the actual legal ownership isn't changing. When the trustee, the person who manages the trust, is the same person who actually owns the property to begin with, then there's actually no legal change of ownership. This is what we see with revocable trusts. These are trusts that can be changed at any time by the person creating them, and they are formed to avoid probate, or that's the main purpose usually to form a revocable trust, is so your assets, like your home, do not have to go through an expensive or lengthy probate process after you pass away when they get passed down to the beneficiaries. So in this type of trust, it's really just a legal extension of yourself. When taxes get reported for this type of trust, it uses your social security number. So really, for legal purposes, no difference in ownership. So there should not ever be a reassessment for tax purposes because it's technically not changing ownership. Now, there are other forms of trust where it definitely legally does change ownership, and people want it to do that, namely for asset protection or other reasons to get assets out of a taxable estate. In those types of trusts, the trustee is a different person than the person who owns the property. So the ownership is actually changing. You're not going to be viewed still as the owner of the asset. So that would be treated differently. But if you are talking about a trust that's being created to avoid probate, a revocable trust, then in that instance, if you're creating a trust like that to put your property in it so that it doesn't have to go through probate, there should not be a reassessment done for tax purposes that would increase the taxes. Now, since this was posted on a Ladybird deed video, and since I do a lot of videos on Ladybird deeds, this is always an option. If you're in Florida or one of the other states that utilizes Ladybird deeds, you can always choose to do that. So in Florida, a lot of times I recommend to my clients, rather than putting property directly into their revocable trust, which you can do, rather than doing that, I tell them they can leave the property out of the trust, leave it in their name, or if they're a married couple, leave it as a married couple. That way they still get the tenants by the entirety's allocation to the property, which could be very beneficial. You can leave it in your name that way, and then it would go into the trust upon the last spouse's passing, or if you're an individual, upon your death. But this is a way to get it into the trust directly upon death to avoid probate, but to also keep it in your name while you're alive so that there is no name change on the property itself. So that would also, of course, help to make sure that there's no change in taxes. So I hope this answers the question. If you have any other questions regarding trusts or Ladybird deeds, estate planning, probate, asset protection, and you're in Florida, please don't hesitate to contact my office, atCause Law Office. The link is in my bio.